ScottTuckerSolutions.com.
Now, from the Signature Bank Studios, this is Chicago's Morning Answer with Dan Prof on AM 560. The Answer.
Top of the morning, Dan Prof here. I got a text from Bob in Buffalo Grove with a screenshot of the temperature on the dashboard of his car, temperature reading -9. Don't you love the news, too, the mindless news, including, unfortunately, our own? Officials are saying don't go out, but if you have to go out, make sure to wear layers and cover your extremities. Thank you. If you don't know how to deal with the cold, even the unholy cold inflicted on Chicago today, at this point, as an adult or as somebody with who is a custodian of children, then there are bigger problems afoot that public officials may need to deal with. Anyway, I digress. Before we get to the topics of law and order that are consuming everyone's attention today, the Jack Smith testimony before the House Judiciary Committee, the arrests made in Minnesota, and the larger issue of federal immigration law enforcement, I do want to take up this gun case out of Hawaii that the Supreme Court took up this week. I mean, it's important. The gun banners that are still in charge of states like Hawaii, they will not stop. They'll take what they can get when it comes to your constitutional rights, like your right to protect yourself. So they have this vampire rule, the so-called vampire rule in Hawaii, where for a gun owner to carry a firearm on private property that is otherwise generally open to the public, they must receive express permission from the property owner. And other states have this too, which is, I'm sure, why the Supreme Court granted cert. The challenge to the law, the argument is not a particularly complicated one, given Supreme Court jurisprudence through Bruin from 2022. They argue it should be up to the property owners to decide if guns are not or are permitted on their properties or not. And so in oral arguments, I mean, this is sort of wild. I guess I should mention the holding in Bruin, 6-3 decision, in which the court held, with Thomas writing the majority opinion, that, I'm quoting from the opinion, when the Second Amendment's plain text covers an individual's conduct, here the right to bear arms, the Constitution presumptively protects that conduct. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearm regulation. Only then may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. So, thinking about these vampire laws, is that consistent with the nation's historical tradition of firearm regulation? I must receive express permission from a private property owner whose property is open to the public in order to carry a gun on said property, or it's presumptively my right to do so, up to the discretion of the private property owner to decide categorically whether guns are allowed or not allowed on their property. Well, Ketanji Brown Jackson took an interesting approach to try to find a way to make the Hawaii vampire law and similar laws in other states comport with Bruin. And this is her exchange with Sarah Harris, who's a Deputy Solicitor General for the United States.
Justice Jackson?
So I guess I really don't understand your response to Justice Gorsuch on the black codes. I mean, I thought the black codes were being offered here under the Bruin test to determine the constitutionality of this regulation. And it's because we have a test that asks us to look at the history and tradition. The fact that the black codes were at some later point determined themselves to be unconstitutional doesn't seem to me to be relevant to the assessment that Bruin is asking us to make. So can you say more about that?
Absolutely. Black codes were unconstitutional from the moment of their inception because they are pretextual laws that are designed to ensure that newly freed slaves are returned to a condition of sharecropping.
Okay, let me stop you there. They were not deemed unconstitutional at the time that they were enacted. They were part of the history and tradition of the country. And when we have a test now that's asking us to look at what people were doing back then, I don't understand why they should be excluded.
Because they are outliers. They are by definition unconstitutional. They have
Found
been
later,
unconstitutional.
afterwards, not at the time. And if the test says what's happening at the time tells us what's constitutional for this purpose, why aren't they in?
Respectfully, a law is always unconstitutional. When it's from its inception,
So the history doesn't matter. We shouldn't care about the history then.
We should deeply care about the history, but the whole point of the Bruin framework is as follows. The history and tradition of the Second Amendment are particularly important because it is codifying a pre-existing right. To figure out in sort of common law fashion what the national history and tradition are, you throw out outliers. And I can think of no greater outlier than blatantly unconstitutional laws that flipped what had been the tradition in states like Louisiana. And during the period before those states were readmitted to the Union, for the purpose of trying to reduce newly freed slaves back to conditions of servitude, made it a new crime, new trespass, in order to go about armed on private property. Those are obvious outliers.
All right,
it should not count under the whole point of Bruin.
Mr. Katyal, address it.
I mean, that's KBJ is willing to defend the black codes, that is, as the means to shoehorn a Hawaii vampire law into the historical traditions of firearm regulation in America. That's something. I mean, that's real commitment to banning guns, I'll tell you that, or infringing on Second Amendment rights, in my view. But let's get the expert opinion of one Professor Richard Epstein, the James Parker Hall Distinguished Service Professor, Emeritus of Law, and Senior Lecturer at the University of Chicago. Professor Epstein, thanks for joining us again. Appreciate it.
This woman is absolutely surreal. One of the sad things about it is you actually read closely the 14th Amendment. It's a much more conservative document than you might have otherwise have thought. One of the reasons that it passed is it guaranteed in its own terms that the federal government would not regulate voting, a provision which has been overturned by subsequent cases. The 14th Amendment, when it came through, was an amalgam of old practices and new practices. And I've just written a book on it in connection with birthright citizenship, and it's a very mixed record, which is exactly what you would expect. So it doesn't get rid of the 3/5 clause. What it says is if you want to keep blacks out of the numerator, you have to keep them out of the denominator. And thereby you can keep the same, you have segregation, but you can't have the same population ratio. There are lots of things like that. But let me put it to the following way. I don't think that the Bruin test is utterly authoritative because there are some problems that never arose at one time or another. And a law like this has never been seen in the face of the globe. And let me start to explain why it is just as a matter of independent common sense. You have a place, and it's called public property. And the question you want to ask is, what do you think the default position should be? And the answer is it should be the position that comports with the ordinary understanding of the way in which people do business. And so you look at any kind of case, any way you look at it, if you have a piece of property and you want people to stay off of it, you say, do not enter private property and so forth. There's never been a case in my history of the world where if you want to go on somebody's private property, you have to get the consent before you can do so if they've not indicated to the otherwise. Now, notice they didn't say breaking and entering into a store. Suppose I want to take a shortcut at the corner and I go across a privately owned parking lot. I'm now supposed to find the owner of the parking lot. I tell him, I have a gun and I would like to be able to cross your property. And he can come back, or the state can come back and say, you entered the property to get the permission, but you didn't have the permission when you entered the property. You were hereby guilty of a felony. Now, you mentioned this as the landowner and the victim and the owner of the property. You have to understand this in context. You're not going to need one person's property. You want to walk 10 miles in the course of the city, you're going to have 1,000 people with whom you're going to have to negotiate.
Right.
Because each of them has the veto power under this particular statute. Now, no private party will enforce this because they're not as insane as the government of Hawaii is. But the criminal fixes can, in effect, put these things into play. So this is what you have to say is history and tradition. This is basically a sneaky, underhanded way to ban the use of guns in Hawaii. Because the moment you have to get the impositions from that, if you get 99% of the people to consent, a miracle in itself, and one person doesn't, you're a criminal. And so you just look at this case, and it certainly comes out the way you said under Bruin, but it also, I think, is pretty clear. It comes out the same way if we just treated this as a matter of ordinary common sense of how property law is organized. Now, there were cases like this with the Jehovah's Witnesses a long time ago, and there they said exactly the same thing. If you don't want to come on the property, please put a sign at the steps before you enter the property so they won't do it. Most people don't put it down on the street. They put it at the door. And so you're not a trespasser until you see the sign, at which point then you have to leave. And that system works perfectly well. What they are trying to do is essentially use a system of ostensible private choice, liberty of choice and so forth, to effectuate a agenda, which is a de facto ban on the use of guns in the state. This case is a no-brainer. The black codes have nothing whatsoever to do with this, and she was wrong about that. I mean, if she actually knew something about the 14th Amendment, she would realize that there's very powerful evidence that they did not want to do the kinds of things which we now routinely assign to the 14th Amendment, which is to regulate voting rights and to prohibit segregated schools. That was not part of their agenda. They had a very different agenda. What they wanted to do is to make sure private people could enter contracts, and they wanted to make sure that the enforcement of the criminal law did not prejudice black individuals. They got equal protection of the law, and they got due process of the law like everybody else. It was a great achievement to do that, but it wasn't what she was talking about. And so the analogy she's making is just nuts.
Okay. I mean, I figured we'd give that short shrift, but I wanted to bring it to people's attention, so I appreciate that. I want to turn to Jack Smith. And, one of the central parts of the cross-examination of Jack Smith by members of Congress yesterday, in my view, was this issue of the speech or debate clause, Article 1, Section 6 of the Constitution, and whether or not Jack Smith's subpoenaing of the phone records of members of Congress and getting an NDO, non-disclosure order, so that members of Congress didn't know and the public didn't know, whether that was violative of Article 1, Section 6, the speech and debate clause. Because if it was, then you potentially have both professional misconduct exposure as well as criminal legal exposure. And so what is your view on what Jack Smith conceded he did and the characterization of that being violative of Congress people's constitutional rights, as was argued by Brandon Gill and others?
Yeah, look, I think that the speech and debate clause is very strange because it really extends beyond speech and debate on the floor. It covers all activities that is incident to that thing taking place. And so by that case, to the extent that they're working on professional business related to this stuff in Congress, I think he's wrong. There's also, I think, another ground. One of the things that you have to understand about this man is he says that nobody's above the law. And what he means by that is nobody I prosecute is above the law. But I'm always above the law because I can do whatever I want and you can't stop it.
Right.
But I didn't think that Jim Jordan gave the correct answer. When Johnson said it's just normal criminal procedure to take anybody and get all their records and to conceal them. The Speaker of the House, who was not even Speaker of the House at the time that this happened, is not just anybody. And so the correct way in which you have to run all of these decisions is to say the following. Is this the guy you want to go for the beginning? And the correct answer is no. What you have to do is first take people who are much closer to the event, their kind of trial, examine their records, And if something in that points to Covenant McCarthy, then you can do it. Excuse me. What's missing in this case is no sequencing whatsoever about how this was done. This is not a first-round cut that you do, and Smith should never have done it unless he had some good reason to believe that these guys were implicated in events which are on the face of the things they were not. So if he wants to go after my friend John Eastman, if he was there at the time, sure, you can go after him. Excuse me. I don't believe that you could go after him and try to keep it concealed from them. I think that the normal rules say you have to get notice of somebody else so they can defend themselves. If you give this as a secret offer, then in effect, nobody can move to try to quash it before it is accomplished. And that is just absolutely unacceptable in the way in which you run procedures.
Well,
they didn't do a very good job attacking Smith. They let him get off much too easily.
Well, but I mean, if your view is that what he did was wrong, it was wrong in what sense? It was wrong in the sense of the canons. It was wrong in the sense of federal statutory law, deprivation of constitutional rights. How is it wrong?
All of the above.
Look, okay, so he does have exposure.
I don't think I think he should. I think it's a violation of the due process clause to go after these kinds of provisions. Due process is always a trade-off. And one of the things that you have to do is, why are you going after this guy? Is this a fishing expedition or is it not? Right. And the only way to go after this guy is to first find somebody who's been directly involved in the event, for whom depositions and inquiries and record collection are appropriate. And then when you look at that, you see the fingerprints of Kevin McCarthy over it. Then you can go after him. But under this point, every member of Congress could have been subject to that kind of treatment. Every former member of Congress could have covered that procedure. So Smith says, I'm above the law because I can choose whom to prosecute. And one of the things that we know about a rule of law is you don't have to secure a conviction in order to destroy somebody's life. What you have to do is file some papers against them, and massive collateral consequences are going to follow. And Smith himself did not acknowledge that. I think he's a very slippery guy. I think he's an able lawyer, but I think he's known to be a tenacious prosecutor who often goes beyond the pale, and in this case, he did it.
My sense of him is, we discussed this a little bit earlier, my sense of him is not so much that he's necessarily partisan, but he falls into the trap that some prosecutors do, which is he's a big game hunter, and you point him at a trophy, and he's going to go get that trophy. And this is the abuse. This is where the abuse of power comes in.
And that's what he did in his prosecution of the governor of Virginia, if you recall. He was roundly denounced by the Supreme Court for his kind of very tough-handed tactic. It's also worse because why did he begin this case? It's because Trump, a couple of days before, had announced that he was running for president. Well, at that point, the incumbent, Joe Biden, who may have had some of his marbles at the time, goes to Merrick Garland and says, we got to get this guy. Yeah. Well, at this particular point, you then have political corruption in the situation. If you recall, Smith also insisted on trying to get a jury verdict out of this case before the election, right? That's also utterly impermissible.
So if you were advising Pam Bondi, based on what we know so far, and there are still areas of inquiry that need to further fleshing out, including these quote-unquote sedition hunters that were paid by the FBI, but would you open a criminal investigation into Jack Smith?
My own view about this is prudential. I don't want anybody to be investigated for anything because I don't trust her any more than I trust him.
I don't want anybody to be investigated for anything. Well, doesn't that make the rule of law difficult?
It makes it very difficult if it turns out there's no separation in practice between the Attorney General and the President. And that was certainly the case both with respect to Biden and Garland and with respect to Trump and anybody he puts in that office, including his longtime buddy, Pam Bondi. And so I think, in effect, your subject that you're talking about is much more serious because there's an entire systematic failure by both parties to have this requisite kind of independence that you need to run an office of the Attorney General is correct. And it's not a question of whether she's appointed or elected.
No,
the same thing
I know.
Blame. She's as bad as the others.
I know, but the horse is out of the barn now. I mean,
this is a very argument, and I'm not sure whether you're right. You're absolutely sure. They're doing it this way. We don't do it the other way. What happens with that, of course, is that it means the furrow gets deeper and deeper and deeper.
I know.
And at which point you're going to get total degeneration. And that's always the case with respect to Trump. Nobody thinks it's wrong to go after and to exploit criminals and violence. But then when you set up a quota, then you have to expose so many people per year, you end up arresting grandmothers who were illegal citizens because they came to this country 45 years ago. The prosecution is a matter of balance and judgment. And you look at the kind of characters that we have running these systems on both sides, none of them have that kind of situation. And so we are in for a very long slog of vengeful politics, and Trump is, of course, the master of that. As you know, when all those prosecutions were going on against him, I denounced them all.
Yes.
I mean, I couldn't believe it. Now, in effect, the lesson he learned is you better be stronger than they are and do it even more outrageously.
Well, but the problem, of course, is, I mean, the politics of this is, of course, you have the left out there right now saying, just wait till we get power again. Wait till we win the midterms. Wait till you see what we're going to do to you next. And so, I mean, if you don't take your shots where you can legitimately, even if, prudence in a different time would suggest otherwise. If you don't take legitimate shots you can take under the law, then you're just essentially sacrificing yourself on the pyre of the left.
Essentially, the argument you are making is I cannot change the rules of the game that they have established and which they have a promise to enforce after you're out of office. And as a pragmatic matter, there's nothing I can say to you, Mr. Prof, have you lost your mind? I'm saying it's a really tough call.
Yeah,
but the way I would try to do it in the middle is before I went on any of these prosecutions, I would make it clear to the public, here are a lot of guys who are marginal. I'm not going to prosecute them. Here's some guy who's really serious. I'm going to prosecute this one. And that shows that I've exercised some degree of judgment, not to simply throw everything at everybody that I can get. That's why it's so dangerous to have them prosecute Jim Comey for statements he made just before the statute of limitations ran. Why he gets airs out judges into these places who are bounced by the court. The way in which Trump could make your claim red is to first prune down his tree. And so he goes after people and announces why I'm going after this person and why I'm not going after this other person. But he's just incapable of making those kinds of judgments. So the answer is you want me to be the prosecutor because I'm going to turn down some cases, right, and accept others. I'm not going to go after everybody who puts on a pair of pants in the morning and goes to work. That's the tragedy. So essentially what you have is dial back, but you don't have to shut off.
Professor Richard Epstein, James Parker Hall, Distinguished Service Professor Emeritus of Law, Senior Lecturer at the University of Chicago. Professor Epstein, thank you as always. Appreciate it.
It was always a fun to be with you, Dan.
You too, and Professor Epstein joined us on Chicago's Morning Answer.
Hear about the big stories of the day, then talk about them right here on Chicago's Morning Answer on AM 560. The Answer.
Perhaps you're a collector, or perhaps all of a sudden you have a collection. Maybe it's an inheritance. How do you know what it's worth? This is Sean Thompson for Donnelly Auction. The market for antiques and collectibles is changing all the time. What is your collection worth right now? Well, I've got an easy way to find out. It's simple. You contact Donnelly Auctions with their worldwide audience of live and in-person auctions. They have a good idea of how to tell you exactly what it's worth at exactly right now. They're ready to put top dollar in your pocket. The bigger the collection, the better. Go to DonnellyAuctions.com and get the info on all things that they buy and sell to have an idea of exactly what Donnelly does and how much they need your collection. They have so many buyers. It's a great time to sell. Just simply make a phone call. Donnelly has traveled all over the country to pick up collections. Just call and talk to the people at Donnelly Auctions at 815-923-7000. Donnelly Auctions is your trusted partner in turning your collections into cash. DonnellyAuctions.com.
AM 560. The Answer.